Court is on the record in the State of Ohio versus Dale Lee Green, case number 25 TRC 40. This case is set for a final revocation hearing today involving a probation violation complaint filed against Mr. Green back on March 9th and March 13th, 2026. There are actually two complaints filed against him. At a preliminary revocation hearing on March 23rd, 2026, Mr. Green, with his attorney Tom Simon, pled not guilty to the complaints filed against him and stipulated to a finding of probable cause.
Judge?
I'm sorry.
This is a sentencing hearing from the May 6, 2026 order.
Yeah, I'm getting there.
Oh, I apologize.
I'm setting a record right now.
I apologize.
That's all right. Mr. Green had pled not guilty on March 23rd, 2026, and I apologize.
Quick reset, because even the judge catches an important mistake here. This is not the final revocation hearing anymore. It's a sentencing hearing. Mr. Green has already pleaded guilty to the probation violations, and sentencing was delayed more than once. That detail matters because the court is now clearly running out of patience. And the big question is, how many delays can a case survive before the judge says enough is enough?
I apologize. This case is set for sentencing, not a final revocation hearing. Thank you, officer. But he had originally pled not guilty on March 23rd, stipulated finding probable cause at a final revocation hearing on May 6th. Attorney Simon tried to get that case or that hearing continued. He could not appear personally because of medical issues, and the court allowed him to appear by telephone. At that hearing, the defendant pled guilty to the probation violation complaints filed against him on March 9th and March 13th. And at the request of the defense, I deferred sentencing. I deferred sentencing until June 22nd, 2026. A motion for continuance was thereafter filed by Attorney Simon on June 18th, 2026, indicating that he could not attend the June 22nd sentencing hearing due to continuing medical issues. The court granted the motion and rescheduled the sentencing hearing for today, July 22nd, 2026. And in that order, I specifically included a condition that no further continuances would be granted. The court finds that Attorney Simon attempted to seek another continuance. He filed that on July 20th, a few days ago, of today's sentencing hearing as a result of his continued medical condition, and the court denied that request. Through telephone communications with the clerk of court staff today, July 22nd, Attorney Simon attempted to participate in today's hearing by telephone, and the court is denying that request. Attorney Simon indicated to clerk staff today that he is continuing having medical issues. In fact, he had told them that he was lying on his back in a bed and could not leave the bed. The court finds that Attorney Simon is not capable of physically, competently, and zealously representing Mr. Green in this case. And I'm finding that removal of Attorney Simon as Mr. Green's counsel is necessary to timely and effectively proceed with the disposition of this case. I'm advising Mr. Green of this in open court today.
Now, this is the moment everything changes. The judge isn't simply denying another continuance, he's removing Mr. Green's attorney from the case. The court is saying that ongoing medical problems have made it impossible to move the case forward effectively. That's a serious decision because the defendant is suddenly facing sentencing without the lawyer who has represented him. Would you agree with the judge's decision, or should the court have waited longer?
Attorney Simon will no longer be your attorney. I'm removing him from this case. I'm not dragging this case on any longer because of his continued medical issues.
Yes, sir.
There's absolutely no improvement from what I'm told with his medical issues, and I'm sorry. I'm not going to allow this case to drag on any further. I'm getting faxed, handwritten requests from him. Faxed. They're handwritten. And they're from a hospital bed somewhere. I don't know. I'm not going to allow, not just in your case, but Attorney Simon to handle any case in this court.
Yes, sir.
So I guess I'm going to ask you, Mr. Green, how would you like to proceed today? You either can retain another attorney, you can proceed and allow this case to proceed to sentencing today without counsel.
Is the, I don't want to interrupt you, but is the agreement that was set in the last hearing, is that still?
Yeah, that's between you two. That's between you all. If you want to have that type of discussion with Mr. Lewis and Officer Benoit, you're going to have to proceed without counsel. And if you're going to do that, I'm going to need you to sign what's called a waiver of counsel document.
So it would probably be in the best interest to hire another attorney?
I can't advise you, sir. You really only have two options. You're either going to proceed today without counsel, or you're going to ask me for a last continuance to reschedule this to allow you time to retain an attorney. But when I say a last continuance, I'm not going to reschedule this thing any further after today, or after that hearing. So again, I'm asking you, if you wish to have some discussions with them,
sir.
so I'm going to have you review and sign a document that's entitled Waiver of Counsel Document. I'm not going to allow you, I'm trying to protect your rights, I'm not going to allow you to discuss this case with any...
If I sign that paper, does that mean I'm representing myself?
And here's the critical legal distinction. Signing that waiver means Mr. Green would be choosing to represent himself for today's proceeding. But notice what the judge does next. The court doesn't simply push him into self-representation. The judge starts exploring whether he qualifies for appointed counsel based on his financial situation. That could completely change what happens next.
Today you are, yeah. You can always get an attorney after today.
I wonder if Mr. Green would qualify for appointed counsel, Your Honor.
Well, I could,
have no idea.
right, I could consider appointing an attorney, but a lot of it that deals with your finances and whether you qualify under the Ohio Poverty Guidelines. So, if you want me to consider appointing an attorney, I can do that, but I'll have to ask you questions about your
Yeah, 'cause
income.
I mean, I've already obviously paid him.
I'm sorry about that.
I don't know what to do, to be honest.
Are you working, sir?
Yes, sir.
Full-time?
For the most part, I mean, I don't have an actual, I'm self-employed, so I don't have like a 40-hour work week job. I mean, I have scheduled contracts for work.
What's your trade? What do you do?
I'm in construction, sir. Heating, cooling, plumbing.
How many dependents do you have? How many people do you support financially?
I have a 10-year-old son.
So one dependent?
Yes, sir.
Do you make more than $30,000 a year?
No,
You don't?
no, sir.
So how much on average do you make every year?
I can't tell you.
Every week or month?
I don't know that answer to be.
Well, you're a contractor. You should know.
Yeah, I mean, it's around there.
Around what?
Probably $25,000, $30,000, I would say, after it's all said and done.
A year.
Yes,
That's
sir.
what you gross or net?
That would be what actually goes into my pocket.
And you only have one person you support.
Yes, sir, I have a 10-year-old son.
And there's the turning point. After questioning Mr. Green about his income, employment, and dependent, the judge decides to appoint the public defender's office. So instead of forcing him to represent himself or immediately sentencing him, the court gives him another roughly 30 days to have counsel present. The original attorney is officially out, a new lawyer is coming in, and this sentencing battle is far from over. Do you think this was the fairest outcome?
Okay, I'm going to appoint the public defender's office to represent you in this case. We will schedule this case for a sentencing hearing in roughly 30 days. So I am going to appoint an attorney to represent you.
Okay, so,
The clerk will provide you at the clerk's window contact information for your court-appointed attorney. We'll also give you a hearing date for that hearing.
so
Okay?
Tom is no longer able to...
He is no longer
Yes,
your
sir.
attorney in this
Okay.
case. And any future hearings,
Yes, sir.
I don't want to hear it from Mr. Simon
I
in your
understand.
case again. So we get constant phone calls from him, and I don't want you coming to court next time saying, oh yeah, I've got Attorney Simon who's going to be handling
Yes, sir.
this. So we're going to give you a hearing date, time for your next hearing. And we're going to give you contact information for your court-appointed attorney, okay?
Yes, sir.
Okay, is there anything further, Mr. Lewis?
No, Your Honor.
Officer Benoit?
No, Your Honor, thank you.
Okay, Mr. Green, you go to the clerk's window, they'll take care of you, sir. Thank you.
Thank you.